The envelope arrived on a Tuesday, which feels important to say because Tuesdays are supposed to be ordinary. I had just gotten back from a 12-hour shift, still wearing my scrubs under my coat, holding a gas station coffee that had gone cold somewhere around the third stoplight. I checked the mail out of habit, not expectation. The return address said Hargrove and Kelleher Legal Group, LLC, Chicago, Illinois. I didn't know that name. I set the coffee on the hood of my car and opened it right there in the driveway, standing in 28-degree air with my fingers going numb. The letter was 4 pages long. The language was dense and deliberate, the kind of legal writing that is specifically designed to make you feel small before you understand what you're reading. But I understood it within 60 seconds. A company called Vantage Property Solutions, Inc. was claiming that I owed them $168,400 in damages, unpaid licensing fees, and what they called unauthorized commercial use of software their subsidiary had allegedly provided to the medical transport company I had co-founded with my former business partner 18 months earlier. They were threatening to file suit in Cook County within 30 days unless I satisfied the debt in full or entered a structured settlement agreement with terms they would dictate. There was a handwritten note paperclipped to the final page. Not printed, handwritten in blue ink in block letters. You don't have the resources to fight this. You know what the smart move is. No signature. My name is Deborah Winslow. I'm 53 years old. I'm a licensed respiratory therapist with 26 years of clinical experience, a former Army Reserve logistics officer, and the person who built a small but functioning medical transport coordination company from nothing, from spreadsheets on my kitchen table and phone calls made during lunch breaks in a hospital break room. I did not inherit money. I did not have investors. I had savings, a second mortgage I took out at a rate that made my sister gasp when I told her, and a business partner I had trusted completely for 4 years. That business partner's name was Marcus Coalfield, and every single thing in that letter traced back to him. The company was called ClearPath Medical Transport Coordination, LLC. Marcus and I had filed the operating agreement in March 2021. I handled clinical compliance, staffing contracts, and hospital relationships. Marcus handled technology infrastructure, vendor contracts, and financial administration. We split ownership at 51% to my 49%, which had been my idea. I wanted to maintain controlling interest because I'd had enough experience watching partnerships dissolve to know that someone needed a tiebreaker vote. Marcus had never liked that arrangement. He'd accepted it because he needed my clinical credentials and my hospital contacts to make the company viable. Without my relationships at 3 regional hospitals and 2 long-term care networks, ClearPath was just a name on an LLC filing. What I hadn't known, what I had no reason to suspect, was that beginning in September 2022, Marcus had begun negotiating with Vantage Property Solutions, a real estate and technology holding company, to sell them a partial stake in ClearPath. He had not told me, he had not brought it to a vote. He had simply begun having conversations with their representatives, using company materials, company data, and company projections to make the pitch. Those conversations had escalated. At some point, and this is the part that took me months to fully reconstruct, Marcus had signed a letter of intent on behalf of ClearPath without my knowledge, authorization, or signature. He had represented himself as having full authority to enter into preliminary agreements on behalf of the company. When the deal eventually collapsed, apparently over valuation disputes between Marcus and Vantage turned their lawyers on the entity Marcus had used to make his pitch. That entity was ClearPath. And because ClearPath's operating agreement listed me as majority owner, I was the one holding the liability. Marcus, by the time that letter arrived in my driveway, had already dissolved his membership interest in ClearPath in a filing he'd made 6 weeks earlier, a filing I had never been notified about and which had been processed without my acknowledgement through what I later learned was a procedural error at the state level. He had already walked away, and he had left the door open behind him so the fire would reach me instead. I stood in my driveway until the coffee cup blew off the hood of my car and skidded into the street. Then I went inside, sat down at my kitchen table, and pulled out every document I had ever kept on ClearPath, which, as it turned out, was exactly the right thing to do. 3 days after the letter arrived, Hargrove and Kelleher called my cell phone. I had been expecting it. The attorney who called introduced himself as Raymond Storch. His voice was practiced in a specific kind of professional pleasantness, not warm, not hostile, just controlled, the voice of someone who makes these calls regularly and has learned which tone produces the fastest capitulation. "Ms. Winslow," he said, "I want to give you an opportunity to resolve this before it becomes significantly more complicated for you." "I appreciate that," I said. "Can you tell me the specific contractual basis for the licensing claim?" A brief pause. "That's outlined in our correspondence." I read the correspondence. The licensing claim references an agreement between Vantage's subsidiary and ClearPath Medical Transport Coordination. I'd like to see the executed contract bearing my signature. Another pause, slightly longer. The agreement was entered into on behalf of the company by an authorized representative. "I'm the majority member of ClearPath," I said. "Nothing above $5,000 in vendor commitment could be authorized without my signature under our operating agreement. I'd like to see which document you're relying on to establish authority." There was a silence that was qualitatively different from the pauses before it. "Ms. Winslow," Storch said, and his voice had shifted, still controlled, but with a different quality underneath it, like something recalibrating. "I strongly advise you to consider retaining legal counsel before this proceeding advances." "That's interesting advice coming from opposing counsel," I said. "I'll be in touch." I ended the call and sat with the phone face down on the table for a long moment. He hadn't been able to name the document. That mattered. The fact that Storch had pivoted immediately to advising me to get a lawyer instead of answering a direct question about the evidentiary basis for the claim told me something important. They were working from Marcus's representations, and those representations might not be backed by anything that would survive scrutiny. But I also knew that not having an immediate answer on a phone call didn't mean they didn't have documentation I hadn't seen. It meant they hadn't expected me to ask. I needed to see what they actually had, and I needed to build my file before they understood how carefully I was going to read it. I want to be clear about something because it matters for understanding what happened next. I am not an attorney. I have never practiced law. I have never studied law formally. And I'm not suggesting that anyone should navigate a significant legal dispute without professional legal counsel if they can obtain it. What I am is a person who spent 26 years in clinical environments where documentation is not a formality. It is the difference between a patient living and dying. In healthcare, you learn that the record is everything. You learn that if something wasn't written down at the time it occurred, in the specific way it was required to be written, by the person who was authorized to write it, then, for institutional purposes, it might as well not have happened. I had brought that discipline to ClearPath from the first day. Every vendor call logged, every contract filed with date stamps, every internal communication between Marcus and me archived, every vote, every decision, every disagreement. I kept records the way a clinical department keeps patient charts, because I had learned that businesses fail the same way patients deteriorate, gradually, then suddenly, and usually because something wasn't documented when it should have been. Within 72 hours of Storch's call, I had pulled together a file that ran to 41 pages of organized documentation, covering ClearPath's operating history from formation through the present day. What I found inside my own records was clarifying in the most unsettling possible way. The first thing I found was a trail of emails between Marcus and a Vantage subsidiary representative named Clifton Ray, emails that Marcus had CC'd to a ClearPath company account that I had access to, but rarely monitored because Marcus handled technology vendor communications. The emails had been sitting there for 14 months. I had never opened them because the subject lines read like routine infrastructure coordination. They were not routine infrastructure coordination. The second thing I found was a copy of the letter of intent Marcus had sent to Vantage, unsigned by me, co-signed by Marcus, and bearing a company letterhead he had generated using our template. The letter represented that ClearPath's majority member had reviewed and approved the terms of the preliminary agreement. That sentence was a lie. And I had a time-stamped record of every document I had opened and approved during that period, automatically generated by the document management system Marcus himself had set up for the company. The third thing I found was the operating agreement. Specifically, Section 7, Paragraph C, which I had insisted be included when we formed the company. In plain language, it stated that no member could enter into agreements obligating the company to financial commitments exceeding $5,000 without written consent of the majority member. Below that, Section 7, Paragraph E, stated that any agreement entered into in violation of those provisions was voidable by the majority member and carried no binding authority over the company. Marcus had signed a letter of intent on behalf of a company he did not have unilateral authority to bind. He had told Vantage he did, and Vantage's lawyers had either not read the operating agreement or had read it and decided I wouldn't know to use it. That was their first error. Marcus had made their second one for them by CCing those emails to a company account I owned. I didn't celebrate. I made coffee, sat back down, and kept reading. 2 weeks after Storch's call, a formal settlement offer arrived by certified mail. Vantage, through Hargrove and Kelleher, was offering to reduce the claim to $94,000 if I signed within 15 days and agreed to a confidentiality provision that would prevent me from discussing the terms or the underlying dispute with any third party. The confidentiality clause was buried in paragraph 11 of a 17-paragraph document. Most people, under the pressure of a 6-figure legal threat with a ticking deadline, would have focused on the number coming down and not on what they were agreeing to in exchange. I read paragraph 11 4 times. The confidentiality clause was worded to prevent me from discussing not just the settlement terms, but the facts and circumstances giving rise to the dispute. In practical terms, if I signed, I couldn't tell anyone, including any future business partner, any potential investor, any licensing authority, what Marcus had done or what Vantage had attempted. I would be paying $94,000 to purchase my own silence about the actions of someone who had committed fraud against me. I called Marcus directly for the first time since this had started. He picked up on the second ring, which surprised me. "Deb," he said. His voice was careful. "I figured you'd call eventually." "I got the settlement offer," I said. "That's probably the right move," he said. "I know it's a lot, but these things get expensive fast when they go to court." "Marcus," I said, "did you tell Vantage that you had my authorization to sign that letter of intent?" Silence. "Because I have the letter," I said. "And I have the emails between you and Clifton Ray. And I have our operating agreement. Deb, listen. I'm not calling to fight," I said. "I'm calling because I want you to understand what I've found before I decide what to do with it." He exhaled slowly. "You should just settle. The whole thing is a mess, but the cost of litigating it is going to be worse than the settlement." "For me or for you?" He didn't answer that. "If Vantage files suit and I defend it," I said, "and in defending it, I have to produce the operating agreement and those emails in discovery, Marcus, what happens to the representation you made to them about your authority?" Another silence, longer this time. "You made a misrepresentation to a company that then structured a business deal around it," I said. "That's not a partnership dispute. That's a different kind of legal problem, and it's your problem, not mine." "You can't prove intent," he said, and his voice had shifted, less careful now, more defensive. "I don't have to," I said. "A court does. I just have to produce what I have and let a judge read it." I ended the call. My hands were entirely steady. I did not sign the settlement. I had assumed after that call with Marcus that Vantage would reassess, that Storch would review the operating agreement, consult with his clients, and recognize that proceeding carried significant risk for them. I had underestimated how committed they were to the strategy of pressure over substance. 10 days after the settlement deadline passed, Vantage filed suit in Cook County Circuit Court. The complaint was 32 pages and named me personally, not just ClearPath. They were pursuing piercing of the corporate veil, an argument that because I was the majority member and controlling operator of ClearPath, I was personally liable for the company's obligations. The filing also included a motion for a temporary restraining order, seeking to freeze my personal bank accounts while the litigation proceeded. I learned about the TRO motion at 7:14 in the morning from an alert on my phone sitting in a hospital parking lot before a shift. I had 48 hours before the hearing. This was the moment designed to break me. A TRO on personal accounts means you can't pay your mortgage, your utilities, and your car note, nothing that runs through a checking account. It's a suffocation move. It's legal, it's aggressive, and against someone without representation and without a clear understanding of how to respond, it works. I called in to work, took a personal day for the first time in 11 months, and went home. I had 48 hours. I had 41 pages of documentation. And I had something else that I hadn't used yet, something I had found in those CC-Ed emails, buried in an attachment sent by Clifton Ray to Marcus in November 2022, that I had almost dismissed as routine. It was a Vantage internal valuation memo. Clifton Ray had apparently sent it to Marcus during negotiations to demonstrate what Vantage believed ClearPath was worth. The memo was stamped, "Confidential internal use only." It had been sent voluntarily by a Vantage employee to a ClearPath email address. Inside the memo was a passage that had nothing to do with valuation. It was a note from a Vantage executive summarizing the acquisition strategy. It described ClearPath as a soft target with a single operator dependency, and noted that the preferred outcome was acquisition at a distressed valuation following pressure application through the legal framework. They had planned this. Not the lawsuit specifically, but the pressure strategy. The memo documented that Vantage's approach to acquiring small healthcare-adjacent companies involved creating legal and financial pressure to force below-market settlements or sales. ClearPath wasn't a unique case. I was a step in a process. That changed everything about how I walked into that courtroom. The Cook County hearing was scheduled for 10 a.m. on a Thursday. I arrived at 8:45. I was dressed in the same way I dress when I testify in clinical review proceedings. Professional, measured, nothing designed to perform emotion. Raymond Storch was already in the hallway when I arrived. He was with a younger associate and a man in a suit I didn't recognize who carried himself like a client rather than an attorney, controlled, watchful, expensive shoes. Storch looked at me without a lawyer beside me and allowed himself a brief, almost invisible expression. Not contempt exactly. More like a calculation that had just confirmed an expected result. "Ms. Winslow," he said, "you're still unrepresented." "I am," I said. "This is a fairly technical proceeding," he said. "I appreciate the concern," I said. He turned back to his associate. I went to find my seat. The judge assigned to the hearing was the Honorable Patricia Okafor, a circuit court judge with a reputation, I had learned in 48 hours of research, for extraordinary impatience with procedural theatrics and equally extraordinary precision when it came to evidentiary standards. Storch presented Vantage's motion with confidence. He argued that ClearPath had entered into a binding letter of intent, that the company had benefited from Vantage's resources and preparation during the negotiation period, that I, as controlling member, was personally accountable for the company's obligations, and that without a TRO, there was significant risk I would dissipate assets before judgment. Judge Okafor let him finish. Then she looked at me. "Ms. Winslow," she said. Response. I stood. I had my file in a binder, 41 pages, tabbed, with a 2-page index at the front. "Your Honor," I said, "I'd like to address the threshold question of whether any binding obligation was ever created, before we reach the question of personal liability." She nodded. "Proceed." I submitted copies of the operating agreement. I walked Judge Okafor directly to Section 7, Paragraph C. I submitted the letter of intent Marcus had signed, pointing out that it bore only Marcus Colefield's signature and that Marcus Colefield held 49% membership interest, with no unilateral authority to bind the company to obligations of this scale. I submitted the document management system records showing that I had never opened, reviewed, or approved the letter of intent records that were automatically generated by Marcus's own system and time-stamped accordingly. Then I submitted the Clifton Ray memo. When I placed it on the record, I watched Storch lean forward. He said nothing, but his posture changed a subtle physical shift, a slight forward tilt, like a person trying to read something from a distance they can't quite close. "Your Honor," I said, "I'm also submitting an internal Vantage document transmitted voluntarily to a ClearPath company email address, which I have full access to as majority member of record. This document describes ClearPath as a, and I'm quoting directly, soft target, and references a strategy of pressure application through the legal framework as a preferred acquisition tool." I looked up from the document. "Vantage isn't pursuing a legitimate debt," I said. "They're executing an acquisition pressure strategy against a company where an unauthorized signatory misrepresented his authority, and they're now attempting to enforce that misrepresentation against the one party who never agreed to it." The courtroom was very quiet. Judge Okafor had the Clifton Ray memo in her hands. She was reading it with the particular stillness of someone who has found something that significantly affects the proceeding in front of her. Storch stood. "Your Honor, the provenance of that document—" "Mr. Storch," Judge Okafor said without looking up from the page, "was this document produced by your client's employee?" A pause. "We would need to verify. The email header shows a Vantage corporate domain," Judge Okafor said. "Is your client disputing that?" Another pause, longer. "No," Storch said. "We are not disputing the domain." Judge Okafor set the memo down on her bench. She looked at Raymond Storch for a moment in a way that I suspect he found deeply uncomfortable. "The motion for temporary restraining order is denied," she said. "I'm also ordering Vantage to produce all internal communications relating to ClearPath medical transport coordination within 21 days as part of preliminary discovery. If the representations made in that memo reflect a documented pattern of conduct, this court will want to know about it." She looked at me. "Ms. Winslow, I'd strongly recommend retaining counsel for the remaining proceedings." "Understood, Your Honor," I said. "Thank you." In the hallway outside the courtroom, Storch stopped me. His face had settled into something controlled and neutral, the professional mask back in place. But there was something behind it, not embarrassment exactly, more like the specific expression of a person recalibrating a plan that has encountered an obstacle they didn't model. "Ms. Winslow," he said, "I think there may be room for a conversation." "I think so too," I said. "Have your client's representatives call me." I walked out of the courthouse at 11:43 a.m. into winter sunlight. Over the following 6 weeks, 3 significant things happened. The first was that Vantage withdrew their suit entirely. Their attorneys cited new information affecting the merits of the claim in the withdrawal filing. The withdrawal was unconditional. They asked for nothing. They received nothing. They simply stopped. The second was that the State Regulatory Office, which had received a copy of the Clifton Ray memo through a formal complaint I filed, opened a preliminary inquiry into Vantage Property Solutions acquisition practices. I don't know what that inquiry ultimately produced. I know it was opened, and I know that the Vantage subsidiary Clifton Ray worked for had its operating registration suspended while the inquiry proceeded. Whether that suspension became permanent is not something I was privy to, and I won't overstate what I know. The third thing was Marcus. I had considered seriously and for a long time pursuing Marcus directly for the harm his misrepresentation had caused me. I had the documentation. I had evidence of a clear breach of our operating agreement and a misrepresentation of authority that had cost me months, significant legal stress, and a relationship with a business I had built with genuine care. What I ultimately decided was this: Marcus had already lost more than he understood. ClearPath was functionally destroyed by the time the lawsuit was withdrawn. The liability cloud and the uncertainty had caused 2 of my 3 hospital partner relationships to go into a holding pattern, and rebuilding those relationships after 14 months of legal limbo was going to take real time and real work. Whatever Marcus had hoped to gain from the Vantage negotiation, he had gained nothing. He had burned his own stake, exited the company under circumstances that would follow him professionally, and handed me documentation of his conduct that would remain on file indefinitely. I chose not to sue him. Not out of generosity, I want to be honest about that. I chose not to sue him because I had already won the thing that mattered most, which was my integrity, my record, and my freedom from a debt I had never agreed to carry. Pursuing Marcus would have meant spending more of my life in courtrooms, and more of my attention on a person who had already taken enough of both. Some people will think that was the wrong call. I understand that. There is a version of justice that requires formal punishment, and I respect the people who pursue it. I've simply learned, at 53, that my energy is a finite resource, and I choose carefully what I spend it on. ClearPath Medical Transport Coordination is still operating. I restructured the LLC in April of last year, updated the operating agreement with language that is considerably more explicit than what Marcus and I originally drafted, and brought in a compliance attorney to review every vendor contract before signing. 2 of my 3 hospital relationships have fully restored. The 3rd is ongoing. Revenue for the most recent fiscal year was $340,000. Modest, but real, and entirely mine. The 41-page file still sits in a binder in my home office. I've updated it twice since the hearing. I add to it whenever something feels worth documenting, which is often. People sometimes ask me, when I tell some version of this story, whether I was scared, whether I considered just paying the $94,000 and moving on. The honest answer is that I thought about it for about 4 hours on the night the settlement offer arrived. I sat at my kitchen table and did the math on what $94,000 would cost me in real terms, whether I could absorb it, whether the alternative was worth the risk, whether a 53-year-old woman with no legal background had any realistic chance of prevailing against a firm like Hargrove and Kelleher. What stopped me wasn't courage. It was something more practical than that. I had read the letter of intent. I had read the operating agreement. I had read those emails. And I understood with the same clarity I bring to reading a clinical chart that the story Vantage was telling did not match the documentation. And in my experience in 26 years of environments where the documentation is the reality, when the story doesn't match the record wins. I was not fearless, I was precise. There is a difference, and it matters. Raymond Storch had looked at me in that hallway outside the courtroom, standing without an attorney beside me, and made an assumption about what I was capable of. That assumption was his client's most expensive mistake, because I had spent 26 years learning that the most important thing in any high-stakes situation is not who has the most power in the room, it's who has the most accurate picture of what actually happened. I had that picture, all 41 pages of it, tabbed, indexed, and ready. If you've ever been told you're finished, told to back down, pay up, or walk away from something that was rightfully yours. I'd love to hear your story in the comments below, and if you believe in standing your ground and fighting back with facts, share this story with someone who needs to hear it today. There are more of us than they expect.